I am Bill Rochelle, the columnist and editor-at-large for American Bankruptcy Institute. Today, I'm reporting on two important decisions by bankruptcy judges 1,500 miles apart on critical issues involving, of all things, Delaware corporate law. First, we go to bankruptcy judge Christopher Lopez in Houston, Texas. He told us in an opinion in December that when an individual who is an owner of an LLC files a bankruptcy petition, that member of the LLC does not lose his or her managerial and voting rights in that LLC. Now, this is a big deal because Delaware corporate law tells us precisely the opposite. Delaware corporate law says that once you file a bankruptcy petition, you lose your voting and managerial rights in an LLC, but Judge Lopez says no. Those provisions are unenforceable in bankruptcy, largely on account of the automatic stay. Next, we move on to a decision just about a week ago by bankruptcy judge Craig Goldblatt in Delaware, dealing with a different but equally important provision of Delaware corporate law. You see, Delaware corporate law tells us that in an LLC, no one but a member or an owner of an LLC can be given derivative standing to bring a lawsuit on behalf of that LLC. Well, back in the years 2018 and 2019, three different Delaware bankruptcy judges both upheld those provisions and said, no, we as a court do not have the authority to give derivative standing to creditors to bring claims on behalf of the bankrupt LLC. Well, Judge Goldblatt took a fresh approach, guided largely, if not primarily, by the important cybergenics decision from the Third Circuit. Bankruptcy Judge Goldblatt told us, as I said about a week ago, that in and of itself, bankruptcy law gives the court power to grant derivative standing for creditors to bring lawsuits on behalf of an LLC. And I said this is important because, one of the fundamental provisions of federal bankruptcy law is that, of all things, property rights are primarily determined by, you guessed it, state law. But it appears as though in these two very well-reasoned decisions that this is an area where state property rights are simply overruled by federal bankruptcy law. As I said, I am Bill Rochelle, editor-at-large for ABI. God willing, I will return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, and a very good day.